So Namaskar, please give us a brief introduction.
Namaskar, sir. Namaskar, ma'am. My name is Akankshya-Regular. I have completed my BLLB honors from Damodaram Sanjeevaya National Law University in the year 2023. Since then, I have been working as a research assistant after completion of the mains exam from November of 2024. My hobbies include singing and cooking.
Okay, madam, you can start.
So, Akankya, what do you love to cook?
Ma'am, actually, my parents, they don't eat onion and garlic. So we often miss out on the opportunity of going out and having dishes or eating out at hotel because we don't have many without onion and garlic outlets. Options. And I also want them to taste all the modern cuisine that we're having, mainly Chinese or Italian or of sorts. So I generally Google or see on YouTube how to make an alternative, how to cook a pasta, for example, without onion and garlic, how to make a Manchurian without onion and garlic. So I often experiment with those dishes, and I like to feed my parents all the dishes that I am able to have outside, but they aren't. And they really enjoy it actually. So I also enjoy cooking those things.
Okay. Okay. Now I can share some situational question as I always ask you. Okay. Now, now you think that suppose we are now facing a scenario where though medical technology has gone to such heights, organ trading plays a major role. The poor people are a subject or victims to such things they are not aware. Let's suppose a kidney, somebody requires a high profile person requires kidney, and somebody has gone for some other operation, which is a regular thing which we find in the news also day to day. Now, what are the steps on the legal ground should be taken? Already some laws are there and they are strict also, but still then it is prevailing. Okay, so what further steps or techniques should be adopted within the boundary of law if to prohibit such cases in the future?
Yeah, ma'am, organ trading comes under the ambit of human traffic. So any kind of human traffic is illegal and is against our fundamental rights under Article 23 of our Indian Constitution. So that has been banned, and Indian Penal Code or the current Bharatiya Nyaya Sanhita also punishes that. But it is still prevalent because there could be various reasons. The first, as you pointed out, that people are not aware. They are often they are often given misadvice from the doctors, and they are forced into operations which are not needed, and in the garb of that operation they are trading the organs first. Second, the thing is that because of economic situation of certain patients, they may be willing to do that. They may be willingly agreeing or consenting to go for organ donations. In garb of donations, they are getting the money, but however, because of middlemen, they are unable to get the exact amount also. They are getting lower than what they deserve. That is the thing. Third thing is that a person, law does not allow commercial organ donation in India or in many parts of the country also. If there is an organ donation, it must be within family. For example, Odisha government recently conducted liver transplantation, which was a very big thing at the SAB Medical College. That also, the patient's wife donated that liver. So within family only it is allowed. These are the things that is happening. What I can do, or within legal limits, what we can do is that conduct regular checks or regular surprise visits at the hospital, checking their inventories, increasing the punishment in case the perpetrators are found to be indulging in organ trading per se, having our intelligence work in a better way to identify where organ trafficking rackets are going on. For example, the medical field should be more under a legal scrutiny that they currently are having. The National Medical Association should be should make stricter guidelines for the same. government hospitals, it is a little bit okay because government is having direct control over it. Private hospitals, nursing homes should be properly registered. They should be constantly under the scrutiny of the government and the law per se, if we are trying to stop organ trading, according to me.
Okay. Nowadays we are seeing that as everybody has a phone and internet is a part and parcel of everybody's life, though the childrens are also in Instagram and Facebook, the freedom of speech is being misutilized in many ways, which gives a very negative vibes to the young generation. And yeah, though there are certain restrictions, but they think that it's a fundamental right to freedom of speech, and they misutilize it. So if such cases arises in your domain, so what are the things that should be considered to restrict such views?
Ma'am, freedom of speech and expression is a fundamental right guaranteed to us under Article 19(1)(a) of Indian Constitution. However, it has its own reasonable restrictions as specified under Article 19 Clause 2, which talks about defamation, public order, morality, contempt of court, etc. First, I'll see what speech is being brought before me, or the material that is brought before me. Is it falling within the restrictions that has been imposed under Article 19 Clause 2? First, I'll try to see that. However, there are certain things which don't necessarily fall under the reasonable restrictions, but they're harmful to the people per se. For example, children, because children's mind are very impersonable. They are like a soft sponge, as we say. So they soak everything that is being given to them. So in that case, social media restrictions need to be very strict, that any person below 18 years should not be allowed to join any form of social media or social media platform. Many countries such as Australia, United States of America are making guidelines to have a stricter view that children are not joining social media, because after 18 years, we also form a reasonable mindset or our own intellect, what to consume and what not to consume. That is one of the arguments that social media advocates give, that social media is, at the end of the day, is a platform where we can choose what to engage with and what not to engage with. But that also comes with a certain level of maturity and intelligence, which children don't have. Therefore, it is better not to expose them at all to social media. So that law should be made so that children, any child below 18 years, should not be allowed to join social media. Recently, social media guidelines were issued by the center, which talks about the same. However, those are only guidelines, not enforceable in law. That is one demerit. Third thing would be to educate parents, because currently children are more tech savvy than parents. We often see the payments, the email ID, social media are handled by the children in the name of their parents. So parents should be taught more, or should be made aware more, to keep a strict check or strict eye on the children, that they are not being exploited by social media. Fourth thing, according to me, specialized cell phones or smartphones should be created, because smartphone today has become one of the necessities, if we may say so, for education necessarily. So that children need cell phones. So certain cell phones which should be created especially for 18 below 18 category, where strict restrictions are there. Certain apps cannot be downloaded, children cannot engage with certain content. So that will sort of nip the problem at the very bud, according to me. So these are my views.
Okay. What is your opinion regarding domestic violence? Yeah, exception being is that the girl is accusing the groom family, but on the contrary, the groom family is innocent. Okay, this is being misutilized. I say the misutilization of domestic violence. Okay, right. Legally, how we are going to have a fair trial in such cases where the accused is innocent? We know that, though he is a boy, and but the family, and that has recently been happened also. So in that case, how you are going to deal if such a case comes to your court?
uh, uh, pro- pro- protection of women against domestic violence are covered by mostly two laws. That is Domestic Violence Act 2006 and Section 498A of Indian Penal Code. Those two sections deal with it. The civil side is covered by 2006 Act and the criminal side is covered by 498A. Civil side protects the woman in terms of maintenance, in terms of shelter, in terms of help from social workers, in terms of residence, in terms of uh, custody of children. That is the civil side. Coming to criminal side, 498A of Indian Penal Code has been misutilized for sure, but it is a very essential section. Just because it is being misutilized does not mean that the section does not have a value or does not have a need. That is why it was included at the first step. Second, judiciary at time to time is trying to curtail the extent of 498A by issuing guidelines. Previously, what happened is once a FIR under Section 498A has been filed, the entire family used to be arrested by the police officer. Police, including the father-in-law, mother-in-law, brother-in-law, even though the sister-in-law is not residing with them, still their family also used to be arrested previously. However, sorry ma'am, I am unable to remember the case law. However, in a series of case laws, judiciary has time and again tried to curtail it by saying that if the per se it is not being shown on record that the family is involved in any kind of domestic violence, they should not be arrested. Aged parents should not be arrested. If the sister-in-law or the brother-in-law does not stay in the same residence and any link with the domestic violence cannot be established, they should not be arrested. So those guidelines has been made by judiciary. Also, recently, Honorable Supreme Court has stated that if any prima facie case of domestic violence is not made out, even the husband should not be arrested and harassed by the police officer. Because though under Section 46 of Indian Penal Code, of Criminal Procedure Code, police officer has the power to arrest in any cognizable offense. However, it is not mandatory for the police officer to arrest. He has to see the circumstances of the case and then only make an arrest if it is necessary. So that is what is happening, and I'll try to enforce the same if any such case of Section 498A comes before me for domestic violence. I'll try to appreciate the provision. However, I'll also see the facts of the case, if whether domestic violence is actually being established from the facts or not.
Okay, sir, over to you.
Okay. So, as I told you, I'll be focusing on exceptions of various statutes. Okay. So, can you tell me what are the exceptions? We'll start with civil law. Can you tell me what are the exceptions to doctrine of res judicata? Especially, in cases which involve fraud or collusion.
Yes, sir. The exceptions to res judicata. First of all, the principle of res judicata is enshrined under Section 11 of the Code of Civil Procedure, which states that if a matter has already been decided by a competent court, the case shall not be entertained or the matter will not be re-adjudicated again by another court. That is what the principle essentially says. The exception first one is that if the court is not competent to pass that particular judgment, then the principle of res judicata shall not come into force. For example, if the court has a subject matter does not have a subject matter jurisdiction to try that particular case, and the court has tried the case, then the judgment will not be enforceable in law. It will not the principle of res judicata will not apply in that case. Second is that if the judgment is obtained by fraud, collusion, or misrepresentation, then the judgment will not operate as res judicata, and the parties can re-agitate the case again before a competent court. Sir, I can recollect these two exceptions.
Okay, fine.
The principle, sir, to add further, the principle of fraud and collusion making the judgment non-conclusive is enshrined under Section 44 of Indian Evidence Act.
Okay, fine. So, what are the exceptional circumstances, okay, under which a suit can be filed against the government despite the bar under Section 80 of CPC?
Sir, Section 80 of Civil Procedure Code states that any suit can be filed against the government, but before filing the suit, a notice of 2 months prior should be given to the particular government, up to the particular official or to the particular department where the suit is going to be, against whom the suit is going to be filed. If it is a central government, then the secretary to the government. If it is a state government, similarly against the secretary to the state government, or if it is in a district, then to the collector of the particular district, the notice has to be given. However, this 2 months notice period can be waived if the plaintiff is able to prove that there exist exceptional circumstances where immediate action has to be taken. However, the government pleader has to be given a hearing for the exceptional circumstance to be allowed and the notice period to be waived under section 80 of the Civil Procedure Code.
Okay, fine. So can you tell me under what circumstances, a suit can be readmitted despite the bar, which has been given under Order 9, Rule 9 of CPC on restoration of dismissed suits?
Yes, sir. Sir, under Order 9, Rule 9 of CPC, it is stated that if the due to the fault of the, sorry sir, I cannot recollect currently.
Okay, fine. So my last question from civil law, you know about the misjoinder of parties. Okay, so what are the exceptions, okay, to the general rule that the misjoinder of parties, it vitiates a suit, okay, under Order 1, Rule 9? What are the exceptions to it?
Order 1, Rule 9 states that misjoinder of the parties will not vitiate the suit, or if any judgment or decree is passed, it will not be set aside or it will not be ineffective. However, if the proper necessary party has not been added, then the misjoinder becomes fatal to the suit and it vitiates the suit. There are two kinds of party per se in a civil suit, that is a necessary party or a proper party. Necessary party means the party against whom a relief is claimed, or in absence of the party, the whatever relief is granted to the plaintiff will become infructuous. It cannot be enforced. He is a necessary party. However, proper party is that though the inclusion of the party is not required, however, it is advisable to have the party included in that particular suit. If that particular party is not added, it will not be fatal to the suit per se. And the exception is if necessary party is not added, then the suit will become infructuous or vitiated.
Okay, now let us come to the criminal law. Okay, so can you tell me under 197 CRPC, okay, so there is, the rule for initiation of proceedings, okay, without the sanctions. So what are the exceptions to it?
Sir, if I remember correctly, section 197 of CRPC states that if any offense of criminal conspiracy is committed, then the sanction of the government, is state government or central government, is required. But I can't.
Committed by whom?
Sorry, sir, I cannot recollect.
I mean, committed by anyone or public servant or particular type of people?
Sir, committed by common people. If a offense of criminal conspiracy is committed against the state by any person, then sanction has to be taken from the government before institution of the suit, if I remember correctly, but I am not very confident with the answer.
Okay. So now under section 195 of CRPC, okay, can I under that, okay, what are the exceptional circumstances in which a magistrate can take cognizance of an offense despite the general bar which has been given under section 195 CRPC?
Section 195 of CRPC states that if any false evidence is given in the court of law, then whichever court has taken in before whichever court the offense has the false evidence has been given, that court has to send a notification or send the official complaint to the judicial magistrate first class for trial of that particular proceeding, the for trial of the offense of perjury per se. And the procedure has been stated under section 340 of the criminal procedure code. However, if the court before which the offense of perjury has been committed, if that court is a court of magistrate of first class, then the judge can directly take cognizance of the same under section 342 or 43. I cannot recollect the section properly. If the offense of perjury is committed before a court of sessions, then without sending the official complaint to the magistrate, he can also try the case summarily or as a summons case. Sorry, sir, as a summons case, the sessions judge can try the case.
Okay. So what are the exceptions to the general principle that, confessions which are recorded under 164 CRPC, they must be voluntary? Okay, what are the exceptions to it?
Sir, section 164 of CRPC states that any confessional statement has to be recorded by judicial magistrate first class, and the proper procedure has to be followed. The exception, as if I can remember correctly, is enshrined under section 28 of Indian Evidence Act, which states that even if a promise of secrecy or even if a promise of any kind of secrecy is given or any kind of reward is given, still the confession will be valid, because it is very natural that confession, it is not necessary that it will be secret or anything per se. But if the proper procedure under section 164 is followed, then the confession will be valid.
Okay. So, can you tell me, under IPC, okay, so what are the exceptions to the general rule that a person is liable for abatement, okay, even if the main offense is not committed? Okay, main offense has not been committed, but still, okay, the person will be liable for abatement. What is the exception to this rule?
Sir, I know the rule, but I am not aware of the exception.
Okay, that is fine. So since this is the last internal interview, so all questions are only on exceptions, okay, which are little bit on the tougher side. Okay, one general question: is there any exceptional condition under which a woman can claim exemption from criminal liability under IPC?
Sir, one exception was there, that is adultery, 497, that even if the woman is the abettor, she will abettor for the adultery, she won't be punishable for the same. She is not made punishable as a abettor also for the adultery, which was set aside in the case of the section was declared unconstitutional in the case of Joseph Sain versus Union of India. However, the same has been incorporated in the Bharatiya Nyaya Sanhita, which clearly states that if any man knowing a woman to be wife of another engages or takes her or entices her to engage in a sexual activity or sexual intercourse with anybody, he will be punishable. So adultery again became reinforced in Bharatiya Nyaya Sanhita, and nowhere the liability of any woman has been stated. So I can only point out that particular exception. Other than that exception, I am unable to point out any such.
Okay. This criminal breach of trust, section 405 IPC. Okay. So what are the exceptions to it under, in cases of good faith?
Yes, a criminal breach of trust states that if any property or any such thing has been given to me under my custody and I have misused or converted it for my own use, I will be liable for or I'll be punishable for criminal breach of trust. However, if under good faith for preservation of that property or for helping anybody else, I have used that property, then I won't be liable for criminal breach of trust. It must not come from a point of deceit or in term for or in wrongful gain or loss. It should be from the point of good faith.
Okay, fine. Madam, you can continue.
Okay, Akankya, how you're going to deal with the issues related to human rights violation?
Ma'am, there is a specialized agency, National Human Rights Commission, State Human Rights Commission, for specifically dealing with cases of human rights violation. However, any offense that has been committed is a sort of human rights violation, according to me. That any injury or any loss to any person is depriving them of some kind of human right that they have. So, as in civil cases, I'll always have the power to impose costs under Section 35 of Civil Procedure Code or under Criminal Procedure Code. Also, under Victim Compensation Scheme, I have power to grant compensation to the victim. So, in that way, of course, I can't reinstate the person or give back the rights that has been violated. At least in some kind of monetary way, I'll try to compensate for the same that has the violations that has occurred against them, according to me.
What is your views regarding euthanasia?
Ma'am, euthanasia is has been in debate since a very long time. The one side being that nobody has the power to take away their own life. The other is being the right of personal liberty, that anybody has the right to do whatever they want to do with their bodily autonomy per se. But in certain cases, euthanasia becomes necessary, which has been acknowledged by our Honorable Supreme Court from time to time. Be it the concept of passive euthanasia, that if a person is solely alive by means of life support, then if the life support is taken away, if that person is unable to survive, there is no value of keeping that person alive. So if passively any person is administered euthanasia, then that is legal. The concept of living will has also been introduced in the case of Common Cause India versus Union of India, that if a person in his lifetime wants, then he can write a living will that if he should not be resuscitated or he should not be put on life support if the time comes so. But I think we should take it a little beyond that. There are certain cases where life becomes so painful that the person cannot add to the society anymore. He cannot enrich either his life or the society's life. The main reason for the illegality of euthanasia per se, the argument that the state gives is that at the end of the day, state is parent of everybody. So it is their prerogative who lives or who does not live. That is how we justify death penalty also, that state has the power to take anybody's life and nobody else than the state has that power. So we have to, it's a very conflicting topic according to me, but I think in certain cases euthanasia should be extended to whatever legal remedy is allowed till now. If the cases allow per se, then it should happen like what we have allowed in case of abortions, legal abortions, that even beyond 20 weeks, if the cases are exceptional, then also abortions are allowed. So in those cases, I think in some cases it should be allowed. For example, life-threatening disease or life-altering disease, where there is no end to it. The person has right to die with dignity, according to me.
Okay. How do you manage stress? Because the more you go as a judge, the stress level increases with the positions. So now you might be facing, but that is very minimal. Okay, when you give a judgment where that affects you emotionally also, and you are in lot of stress also, so how you are going to handle stress in your job life?
Uh, Ma'am, I have seen firsthand. I am working at Honorable Odisha High Court. I am assigned to honorable judges and seeing their daily life. It is so stressful. From there is no working hours per se. Every hour of the day, every waking hour is sort of a working hour. And at first, I used to get very. I used to get drained seeing them only, that they are becoming so tired and drained every day. But they have that integrity for their job or dedication to their job. They never complain. So that virtue I have taken from them, that never to complain, have always have a light take on life, never take anything too seriously that it starts affecting me. Third tool for me is family. I always come back to my family. I discuss with them. I try to keep my work out of my family life, or whatever is happening in my life. I'm close to my family per se, and I try to decompress with them. Fourth is spirituality. Spirituality has helped me a lot. I meditate, I go to temples, I pray. I believe that there is an energy, and we see it in form. We have to see it in some form, and I see it in form of God. And at the end of the day, I leave everything on Him to decide for me, and that sort of complete surrender helps me de-stress my mind. Fifth would be seeing it from a broader perspective, not seeing it in a micro level, rather seeing from a macro level, and seeing that is it going to affect me for a very long time, and that in that way prioritizing my tasks. So these things help me manage my stress.
Okay, last question from my side is that, because we are not next going to have the face on. So, as you believe in God, so by grace of God and hope that comes true, that you are selected this time, then where do we see Akankya after 10 years?
Ma'am, professionally or personally or both?
Both.
Both. I'll start with professionally. In 10 years, I'll be 35 years. So if that time during that time, if I have not been promoted, I'll probably appear for the district judicial services and try to go to the next hierarchy. That is in terms of career goals, but in terms of daily career, small career goals, I'll try to do my job very well. I'll try to do justice and try to help people as much as possible. I'll try to keep my case disposal rate higher than what it actually is. That is what I see myself doing professionally. Personally, I'd like to travel a little more, see different places, read more, because we can't have all experiences in our life. We can only experience everything if we read everything. So I try to read more. Probably I'll get married. That is what taking care of my parents. My parents should have retired by then, so they would be old also. So trying to take care of them, fulfill all their wishes. So that is
I
how
hope
I.
that comes true. Okay,
Thank
and
you.
hope that you crack and you have a very good rank also this time. Okay,
Thank you.
over to sir. Are you going to give the first evaluation or should I do?
Now, I have a few questions remaining. Akanksha, you said that you believe in God. So recently, our ex-Chief Justice, not recently, when he was the Chief Justice, Honorable Justice T.Y. Chandrachud, he was criticized a lot because he was seen worshipping, the gods of the religion that he believes in, along with the Prime Minister and all. So my question is the extrapolation of that. Uh, Being, a judge in the judiciary, how will you balance your religious beliefs and the general perception which is there, that the judge, okay, should have no religion, or maybe in some countries, it is preferred that the judge is an atheist, or at least publicly does not show his religion. Okay, how will you balance it, and what is the concept which is there in India. That has been beautifully explained by Justice Chandrachud himself. But still, what is your point of view regarding this?
Sir, I'll start by quoting what Honorable Justice said, that to be a judge, I don't need to be an atheist first. Because really, at the end of the day, religion is a identity that we are given or that we identify with from our childhood. From the point we are born, we are assigned to certain religion, and it depends upon us to practice it or not. That is the beauty of India, that it is a secular country. If we want to practice certain religion, we can do it independently. If we don't want to practice any religion, we don't want to do it. Nobody will force us to do it. That is what is the beauty of our country. And that is what has been incorporated in legal system, that no post has been barred for any religion or has been made specifically for any religion. That is our religion neutrality. And having religious views does not necessarily impact or will have any impact on my judgment, because judgment are given on particular facts, seeing the documents or evidences that are produced before us, and it is very peculiar to our own that particular facts, and it does not have to do with any of my own views, because judges has to be without any bias. So how does it make any difference having any religious views or having any views on any particular socio-economic event that is happening in any part of the country? So if we see, so we should just become a machine which does not have any feelings. So I think I possess that quality, or every judge should possess that quality, to differentiate between the personal and professional life, and not let any part of personal life crawl into their professional sphere. And I think I'm confident that I'll able to do it. And my religious views are very personal to me. My religion is very personal to me, and I respect it a lot. And it is a form of social glue per se. That is how we feel a sense of belonging. And I get my identity from there, and I'm very proud of it.
Okay, fine. So that will be the end of the interview. Now let us come to the analysis. So from the legal side, I focused more on the exceptions to the various statutes. Okay, so more or less we're able to answer most of the questions. Okay, because exceptions are a little bit tricky. Okay, they're difficult, so we keep that for the last internal interview. So more or less you did well there. Another, your flow of speech, your opinion is quite clear and balanced. Okay, so I'll give you around 75 out of 100. Okay, for today's interview. So I'm expecting a very good rank from you. Okay. Madam, your analysis.
Yeah, Akankya, your last time also what I stand by that your views, your opinions, because I generally deal with that psychological aspect as well as the situational questions. So it is very much clear and convincing, to the point, within the legal boundaries. You are also specifying the laws that are associated with it, so it becomes convincing that you are aware of that, and their how they are used in these particular situations. So hope that this will be continuing throughout your life, that you will be growing further. Okay, and also, as sir told it, Lord Jagannath blessed you that you secure a good rank. So all the best for your exams, for your interviews. Okay.
Thank you, ma'am.
Thank you.
Sir, actually, I am sort of because